Good morning, counsel.
Good morning, Your Honors, and may it please the Court. Matthew Beauvais on behalf of the defendant, Mr. James MacDonald. The defendant requests that this Court reverse his convictions and in do so reach three conclusions. First, visual inspection alone, absent corroborative composition testimony, is insufficient to meet the Commonwealth's burden that a specific substance is a drug. Second, upon the defendant's request, the judge issued an instruction to the jury notifying them that the Commonwealth possessed the ability to submit a substance for forensic testing when it only offers opinion testimony as to that substance. Third, that an expert's testimony that certain acts or behaviors are consistent with a crime is an improper comment on the defendant's guilt.
Now, let me ask you, let's imagine the issue in a case, probably a civil case, is whether or not something is a mushroom as opposed to another fungi. And the party brings in a botanist who says, I know mushrooms, and this is a mushroom. This in the class of fungi is a mushroom, based on my experience, based on my observations. Any reason why that is not appropriate expert testimony?
No, Your Honor, that's not inappropriate expert testimony. What the testimony hinges on, however, is the expert's ability to describe what he or she knows and then be able to articulate how the expert came to the conclusion that, in your example, it's a mushroom. In this case, Detective Sergeant Montana testified that by looking at the substance in the bag, as to the expert testimony, that he looked at it based on his experience, it was consistent with marijuana. Based on the presence of seeds, it was consistent with seeds he had seen in previous seized marijuana in his experience. He did not articulate to the jury how his experience led him to this conclusion.
But
wasn't that implicit, though?
Yeah. I mean, he had all these years and investigations up the yin-yang with marijuana. So wouldn't it be implicit?
He testified to many, many years of investigating drugs and courses he had taken in it, and furthermore, he had spoken with drug users and drug distributors. So what more would you want other than an admission that he had smoked marijuana himself?
Your Honor, that...
And I don't even know why that would be relevant. I mean, what more would there be?
Your Honor, that testimony given by Detective Sergeant Montana describes what he knows through his experience. He did not offer testimony to the jury as to how he was able to make the identification specifically. Admittedly,
he said the leaves and the seeds. If he had perhaps if he had burnt the marijuana right in the courtroom and smelled it and said, I recognize this very distinctive smell, that might have been more definitive. But he said he recognized the seeds and the leaves.
But that's expressly to the point here, Your Honor. He did not offer any physical descriptors aligning what he had in his hand to what he had in his experience.
But the jury could see it. He didn't need to say it's a 2-inch by 1 inch by a 1/4 inch, whatever inch leaf. They could see how big it was. And he said, this leaf looks like leaves that I've seen that are marijuana.
Yes, but Your Honor, he did not offer any explanation as to how he reached that conclusion. As to Your Honor's point that the jury could see.
When you say somebody looks like somebody else, I mean, what looks like the person I saw there, what more can you say?
One can address either, in your example, hair color, facial structure.
Well, he said he addressed the color.
He addressed the color, yes, Your Honor, but the description that, in this case, marijuana comes in green, brown, and gold, and that he identified this as brown, doesn't specify anything more that this is arguably a dried brown herb in a bag, which could be one of several different substances.
But it also has seeds that I recognize as seeds of marijuana.
On a similar front, Your Honor, he gave no indication as to how those seeds were consistent with marijuana seeds other than by saying they were consistent with what he saw in the past. He admitted on the stand that seeds are necessary in order to grow marijuana. And the presence of seeds or stems in the bag is not an indicator that this is a particular herbal substance that he identifies as such. He offered no description of the seeds or how they were consistent specifically with what he saw in the past. He did not tie that past experience to this present observation.
If he had opened the bag and smelled it and said, this is consistent, I mean, this is the smell of marijuana, I know I've smelled it 4 million times, would that be enough in your view?
Yes, Your Honor. Something more than visual observation. In the case of Commonwealth versus Keller, which I cited in the brief, which is an unpublished decision in the appeals court, which was recently affirmed on remand from this court, the question arose as to whether the officer had experienced smelling raw or burnt marijuana.
Were the leaves in this case, the marijuana leaves, were they intact leaves or were they ground up?
It's been represented to me from trial counsel and the defendant that these were shredded leaves, not powderized leaves, but shredded is the best word that I can use for what they.
So you couldn't see the leaf shape? Is that what you mean? I mean, you couldn't.
From my understanding, it was not a full.
Do we know that from the record?
A full leaf. No, Your Honor, we do not know that from the record.
Can you refresh my memory? Did he indicate how many years he had been doing this, and did he give any estimate of how many times he had testified about marijuana?
Yes, Your Honor. Detective Sergeant Montana had approximately 40 years of experience.
How many?
40 years as a police officer. 20 of those were in charge of the drug control unit out of Medford. He testified that he had been on, and the Commonwealth may correct me on this, dozens of buys. He had thousands of cases involving drugs.
Well, given all of that, why isn't that enough for someone who's had so many years of experience, so many involvement in thousands of cases to say, yep, this is it, same stuff I've seen before? You're saying there had to be more than visual observation.
Yes, Your Honor.
Is that because a good number of things look like marijuana? I mean,
Yes,
it
Your
could be oregano, it could be a bunch of other things.
I strayed from making the oregano argument in the brief, but that goes to the point. If the purpose of expert testimony is to provide the jury with tools on which to find a fact, and the only testimony that they're given is one officer's opinion that this looks like material that he has seen in the past, the jury is not given the appropriate tools in order to find that fact on their own. They are being told that fact. So evidence of either smell, as Justice Botsford raised, or consumption, as was present in Dawson, or presumptive field tests, as was present in Connolly. These are additional pieces of evidence regarding composition of the substance.
What about feel? Did he heft it? Did he touch it in this bag?
He felt it through the bag, Your Honor, and he testified that he took courses that instructed him on what certain substances feel like.
So we're talking not just visual, but also tactile. He was feeling it.
He felt it through plastic, Your Honor. That's arguably entirely different from actually having something in his hand where he could make that identification.
So if he had stuck his hand in the bag.
Well, if he had put his hand in the bag, not only would he had the opportunity to testify as to the odor, but he would have had the opportunity to testify to the feel of the substance itself. That may have gotten over this hurdle, but he did not testify to that. The bag was not open, and this was the extent of his testimony.
Well, help me. I'm trying to think if somebody testifies that somebody is suffering from mental illness, the expert lists the descriptive, what would make various types of mental illness, and then says, I examined this person exhibited this, this, and that. Therefore, it's my opinion that she is suffering from a mental illness. Now, what would be the difference here?
That goes to the defendant's third issue, Your Honor, and that is, I've been presented with this scenario.
Are you talking about the hypothetical?
Yes, Your Honor.
Well, my question on that is, what else would the expert he has to base his opinion, his or her opinion, on a hypothetical based on facts and evidence. You can't ask a hypothetical based on other facts.
That is correct, Your Honor.
So you've got, the questioner has to put the facts and evidence to the expert. The questioner cannot use other facts.
In a hypothetical question, yes, Your Honor. But if the purpose of expert testimony in this regard is to describe or decode cryptic conduct for the jury to make up their minds as to whether the defendant committed the crime, to lay out exactly what occurred, as in this case.
Well, what
brings
else
them
should he
too
have laid
close.
out? Should he have laid out facts that were not in evidence?
No, Your
He
Honor.
couldn't do that. It would be inadmissible.
No, Your Honor, but it would be consistent with this court and the appeals court's jurisprudence regarding expert testimony of this type for the expert to testify to what cryptic conduct means. And in this case, Detective Sergeant Montana did that. He testified to the general behavior of a street-level
Okay, so
drug
is what you're
transaction.
saying that you can't ask the expert a hypothetical question then?
It gets too close, Your Honor. It gets
So
too
no,
close.
but I'm asking you what your position is.
The defendant's position is the hypothetical question that lays out the specific facts of the case.
But given the fact that any hypothetical question must consist of facts that are in evidence, are you saying that, and if it consists of facts that are not in evidence, it's not a proper question? So what is your position as far as hypothetical questions?
That the hypothetical questions in criminal cases like this should not be allowed.
Because I take it your point is there is no difference between saying if Sergeant Detective or Detective Sergeant, I guess it is, Montana had been a precipient witness and said, I saw exactly what he testified to as the hypothetical, and in my opinion, that's street-level dealing. That you couldn't do.
Yes, Your Honor.
And you're saying it's a total distinction without a difference to be able to say, well, I didn't see it, but if you tell me these very specific facts, I will tell you that that's consistent with street-level dealing.
Yes. Admitting the fact that it's the answer that is the evidence rather than the question that is the evidence. What the jury heard in this case is that on a Saturday in October in 2006 at approximately 4 p.m. in the afternoon on a street in Somerville in front of a KFC restaurant, John Doe did the following 8 things. And then at the end of that question, Detective Montana testifies that that behavior is consistent with distribution. He then later says that in his opinion, John Doe is the distributor and that the individual in the car, the Olds Cutlass, was the user. What the jury hears from this is John Doe is the defendant, and Detective Sergeant Montana, even though he was not an investigatory officer or a recipient officer, saying that in his opinion, John Doe, the defendant, is guilty of distribution. The consistent with locution serves no educative purpose in this regard. The better testimony would have been to have Montana stop after he explained the distribution chain, packaging, how street-level drug transactions work.
Let me just ask you a couple of questions about going back to the first subject. If this case did not involve this kind of marijuana, but plants growing someplace, and the police came in and seized the plants themselves and took pictures of the plants, showed the full leaf, height of the plant and everything, all the details, close-up details of what it looked like, and an expert testified based on the photographs that this plant was marijuana. Do you have any problem with that? If it shows a full leaf in the height of the plant?
That is certainly a closer question, Your Honor.
So how do we know whether no expert can testify to the identity of a particular biological substance or a biological organism as not being something or being something, just based on a visual observation?
Well, to reiterate the answer or to explain further the answer to your first question, if we're discussing full plant stalks, full leaves, this is a condition that can be compared. It can be viewed. There have been cases, not only the extra-jurisdictional cases cited by the Commonwealth, but those here where substances have been compared to either nationally reviewed databases or physicians' desk references. And in the case of a whole stalk or a full leaf, that gets a little bit closer because then you have tried and tested materials for comparison. And I think in that instance, Your Honor, it would be acceptable for visual identification because you have more than just the expert's opinion on it, but it has some substantive composition evidence as well.
Now here, did the defendant object to the expert testimony?
No, Your Honor, the defendant did not object to the
So,
qualifications.
and are you claiming that in the absence of an objection, the judge should have using his or her gatekeeper authority, not allowed it in?
No, Your Honor. The defendant's position is that the motion for required findings should have been allowed based on this.
Okay, so you're saying the evidence is admissible as expert testimony, but it is too weak to support a finding of guilt?
Yes, Your Honor.
Thank you, sir. We'll have to leave it there.
Thank you very much, Your Honors.
Good morning, Your Honors. My name is Loretta Lilios. I'm an assistant district attorney with Middlesex, and with me is Jennifer Handel, who was the trial prosecutor in the case. This court has long held that the testimony of an experienced officer or an experienced drug user, for that matter, can identify a controlled substance, and that scientific analysis is not a prerequisite for the identification and for the case to reach the jury. And
Our cases say that, but this is marijuana, so maybe it falls in a slightly different category, or you suggest it does. But what if the officer came in and said, yep, that white powder, that looks like heroin to me. I've made a lot of heroin arrests, and that looks like heroin for me. That's sufficient?
Well, standing alone, I would have some question about that, Your Honor. But the linchpin of whether the witness's testimony would be enough for the Lattimore standard rests in whether or not it's reliable. And for reliability, the witness would have to be qualified by his experience, and he would have to have had the opportunity to have made enough observations of the substance. And his opinion would have to be based on the type of information that an expert in his field of expertise would typically rely on. And if that sufficient amount of reliability is established, then the case would go to the jury. And I would point the court's attention to
So does there need to be a Lanigan hearing? Could there have been a Lanigan? Let me ask it that way. Could there have been a Lanigan hearing in this case?
Now, the defendant does not argue here, nor does he argue below, that the expert's testimony was not admissible or was not of the type of information that that would be susceptible to expert opinion. If he had argued that, then we would be in the realm of a Lanigan hearing. If the court then found that the testimony was not admissible, the remedy would be for a retrial and not for a reversal.
Now here, he does cite state police, I think, regulations that say you should not give an opinion about the nature of a particular biological substance unless you've had the chance to touch it, feel it, and smell it, and taste it.
The protocols that he cites do not exactly say that, Your Honor. Those are protocols that state police are to follow once evidence is submitted for scientific analysis, which really makes the protocols completely irrelevant to the question that's before this court, which is whether, absent a scientific analysis, an expert opinion alone, without the drug cert and without the scientific examination, is sufficient. So the protocols tell police what to do when there is a chemical analysis. So I submit that they're not relevant to the question here.
Isn't the issue here, though, that because marijuana looks like many other plants, or certainly a sufficient number of other plants, that the amount of evidence to which Detective Sergeant Montana testified, that is, he felt a plastic bag, he said, well, marijuana comes brown, green, and gold, and this is brown, and he said, I see seeds that are consistent. That just isn't enough. If he'd smelled it, it would have been enough. If perhaps he had felt it, it might have been enough. But just the limited of what he said, given the context, it's not a unique substance, isn't enough.
Well, the defendant does argue that, but in fact the detective spoke to many more distinguishing characteristics of the substance than that.
I'm looking at what you have in your brief. What else?
Well, he explained that there was a difference between marijuana that was grown in different parts of the world. He explained what that difference was, both in terms of potency and in the way that it appeared.
I wondered how all that was relevant.
Why does that tell you what's in this bag?
Well, he explained that in one type of marijuana there are more seeds and twigs, and from that the jury could infer that he not only observed seeds and twigs, but was able to determine where the marijuana originated from. And he also spoke to the color of the marijuana and the mere fact that he did not smell the marijuana. That, first of all, should not be taken as any criticism on the type of evidence that was elicited by the prosecutor, since there can be many reasons why that question wasn't posed. But there is also a substantial amount of other corroborating evidence in terms of the nature of the transaction and his expert testimony explaining the nature of the transaction, as well as inferences that can be made from the buyer here as inferably a repeat user.
But, I mean, you know, as we keep saying, and I mean, it could be fake, right? I mean, the fact that there's a drug transaction does not tell you a whole lot about whether this is actually marijuana, which is, of course, an element that you have to prove.
Your question, Your Honor, about a counterfeit substance, I think that the Melendez-Diaz lines of cases, that your question rises out of a concern in those cases, where in those cases, in order to survive the wrongful admission of the certs and a Crawford violation, the court has to look at whether the remaining properly admissible evidence was so powerful as to overcome the wrongfully admitted certificates. And in fact, the Melendez-Diaz line of cases says that it would not be enough to show that the remaining evidence was sufficient to convict. So I think the possibility of a counterfeit substance is an appropriate area for cross-examination in this case. And in any event, concerns about counterfeit in this case are addressed by evidence that the buyer was a repeat user. There was a partially smoked joint in his ashtray. There's evidence that he knew the seller. There's evidence that the seller and buyer knew one another, and it can be inferred, not as a necessary or inescapable inference, but certainly as a possible inference, that this was a repeat transaction between the two.
Can I ask you this? I know there wasn't a Lanigan hearing here, and as Justice Spina suggests, maybe there needs to be in these cases. But is it your position that an expert in the field would rely on what the officer relied on here to form an opinion, an expert opinion, as to whether or not this was marijuana? That is, I saw it through a bag, looks like it, and I touched it through the bag. And would an expert, was that what an expert in the field would rely on?
I think there is a long history in Massachusetts cases and cases throughout the country of testimony like that being admissible and admitted and accepted in courts.
Yeah, but was it really like that, though? Limited to feeling a substance, a small amount of a substance in a plastic bag? I mean, didn't it involve people who actually handled it directly and smelled it? It involved more than just an appearance through a window.
I'm not aware that the cases limit the admissibility of an officer's testimony on that basis, Your Honor, that he have direct contact. In fact, I can't think of any of the cases that either of the parties have cited in their briefs that limit it in that nature, especially given the types of qualifications that this officer had, which really are not called into question even by the defendant. I think the case here is analogous to a police officer who makes an arrest on an OUI case based on his administration of the field sobriety tests and his opinion that the operator is impaired, and yet the case goes to the jury without a breathalyzer test. Now, of course, the Commonwealth would love to have a test that shows a .08 or higher, but the mere absence of that test does not mean that the case cannot reach the jury. And
why wasn't the bag opened here? So the officer could have felt it through the bag, smelled it, even conceivably burned it.
Well, that question was not asked of him, but I think there are reasons that are not speculation as to why he was not asked to smell the marijuana. The exhibits do
What?
still exist.
What?
The bags are not of a huge quantity, which could affect the amount of smell. This is an officer with 40 years on the job. I don't think it's crazy to think that one's sense of smell deteriorates as one ages, and I don't think that any improper inferences can be drawn by the fact that he did not smell it. But I would hearken back again to the fact that there is ample corroboration in the case of the illicit drug transaction to corroborate the officer's.
As you can imagine.
Doesn't this really boil down to kind of to draw the analogy to obscenity, where they say, I know it when I see it. This officer with 40 years experience, 20 of which were involved in a drug unit, says, I looked at it and I know it to be marijuana.
Well, I think it goes well beyond that, Your Honor, because I think this officer did a terrific job of actually describing characteristics that could be understandable and observable to the lay juror, in the same way that a gourmet cook may know the difference between rosemary and parsley, but someone else may not. If the cook were able to point out the distinguishing characteristics of those two herbs, it is something that someone with no experience in the kitchen could easily understand and adopt. So,
But in this case, did the expert ever say that it was marijuana as opposed to it looks like marijuana?
I believe he said that in his experience, it was consistent with marijuana.
It was consistent with? That's the language. I mean, well, let me ask you this. I haven't looked at the transcript. If all he said, if his opinion was this looks like marijuana, would that be sufficient to permit a finding that it was marijuana?
I believe so, Your Honor, especially with all of the corroborating evidence that was apparent in this case.
Okay, so you're saying, well, of course, all of that could be also consistent with a ripoff for a bogus marijuana. I mean, the person is buying what the person thinks to be marijuana. Shouldn't there be somebody in the case who says that this is not merely something which looks like marijuana, or the buyer thinks is marijuana, but actually is marijuana?
Well, again, I'd harken back to, I think that the counterfeit aspect of it is an area appropriate for cross. And, of course, in this case, there's some element of gamesmanship here, because the defendant well knew that a scientific analysis had been performed and that the substance came back as marijuana. In fact, he even crossed this officer on that he personally did not did not personally perform the scientific analysis. And arguably, the Commonwealth even could have redirected the officer on the fact that that the analysis had been performed as a proper basis for his expert opinion.
Okay, but you're still responsible to provide sufficient evidence to convict. Are you saying that the defendant's conduct in some fashion diminished your responsibility to provide sufficient evidence to convict?
I'm sorry, Your Honor.
I'm not sure what you say that it's the defendant's fault, but the issue here is whether or not the evidence in the record permits a rational juror to convict. And conviction requires there to be a finding not merely that it looks like marijuana, but that it was marijuana. And I'm asking you whether or not an opinion that said simply that it looks like marijuana, consistent with behavior that makes it clear that everybody understood, believed it was probably marijuana and bought it on that pretext, is sufficient for a conviction of possession or distribution of marijuana.
Well, the officer here testified that by looking at the bags and feeling them, he can see and he can feel that there's seeds in there, there's twigs in there. He comments on the colors. It looks like marijuana. He believes it to be marijuana. And he goes on to talk about the particular type of packaging. And in his training, this is the type of packaging involved. He also goes on further to talk about the denomination of the bags, which appear to him to be a standard denomination of what's known as a dime bag, which now goes for $20, which then is corroborated by the denominations of cash that are in the defendant's pocket.
But you're reading something which he said, I believe it to be marijuana? Is that what he said?
And he
That was in
believed
the
it-
prosecutor's question.
That's correct. And he then goes on to say that the seeds, he adopts, the prosecutor asks, are those seeds specific to the drug marijuana? And he says, yes, you need the seed to grow the marijuana. The
I
prosecutor.
suppose you're asking us, the officer actually testifies, to me it looks like marijuana. Then the prosecutor says, what are you basing that opinion on that you believe it to be marijuana? That's a change. And the officer answers the color. I suppose you're asking us to infer from the question that the officer is agreeing with the expression of the prosecutor that he believes it to be marijuana.
Well, yes, and I think that is, a standard that an adoption of the prosecutor's question does amount to, that the witness adopts it in his answer.
Can I ask you, again, marijuana may be one thing. Maybe it's much more identifiable just by appearance. But this same officer called, with all of this experience, called to testify as to whether or not a white powdered substance is cocaine or heroin. Do you think it's the same thing? Do you think there's something different about those substances that requires more than just an officer's opinion that it looks like cocaine or heroin?
I think standing alone, a mere comment that a white powder is cocaine or looks like cocaine may be lacking. But I would draw the court's attention to the Jackson case, in which review was denied, but which was remanded to the appeals court subsequent to Vasquez. And in that case, the appeals court found that the wrongful admission of the certs in violation of Crawford, that the conviction for cocaine still stood under a harmless, beyond a reasonable doubt standard, where the officer commented on the substance as cocaine by describing that white cocaine can turn greenish in color when it's put in a bag damp, and mold can form on it. So I think there can be potentially specific and distinguishing characteristics of cocaine and heroin that an officer could testify to. It's not the case in front of us, but I would not concede that the expert's opinion in a cocaine or heroin case standing alone would not be possible.
Thank you, counsel.
Thank you very much. I'd ask that you affirm the convictions.